Welcome to the Bar Association of Montgomery County, Maryland, and the Metropolitan Washington Employment Lawyers Association's October webinar, Zooming into the Future, Lessons from 2 Years of Remote Proceedings. I am Scott Oswald. I am MWELA's Bench Bar Chair and your moderator for today's program. Before we begin, Stephanie Perry, President of the Bar Association of Montgomery County, has joined us. And she is going to tell us a little bit about BAMC. Stephanie?
Thank you, Scott. And on behalf of the Montgomery County Bar Association, welcome everyone. We are delighted to be partnering again with the Metro Washington Employment Lawyers Association and thrilled to see that we're going to have a wonderful turnout today. Scott and our speakers have put together a terrific program for you that I'm sure will be helpful to you in your practice. This program is really just one example of the many benefits that the Montgomery County Bar Association membership brings. And it's also a really good example of the Bar Association's valued partnerships with our various specialty bars and affinity bars, and the ways that we really do try our best to contribute to the success of our members. For those of you who are not already members of the association, hopefully you will be encouraged today to learn more about the association and ultimately to become a member. You can find us online at barmont.org. That's BARMONT.org. Welcome again, everyone. Thank you for joining us. Thank you again to the Metro Washington Employment Lawyers Association for this partnership opportunity. And we hope to see you at future Bar Association events. Thanks so much, Scott.
Stephanie, you're welcome. And again, thanks for co-sponsoring with us. We are very grateful to you and all of our members at the Bar Association of Montgomery County. I am ready now to turn to our participants in today's roundtable. Cheryl McCally has been an associate judge in the Montgomery County Circuit Court since 2010. Before that, she served as an associate judge in the District Court of Maryland and as an assistant state's attorney in the Montgomery County State's Attorney's Office. Daniel Clark is an attorney with the Washington, D.C. office of Kator, Parks, Weiser, and Wright. Daniel served as a law clerk for the Honorable Irma Raker, a senior judge of the Court of Special Appeals of Maryland during the 2015 to 2016 term. Rodger Robertson is a senior counsel with Travelers Insurance Company. Rodger handles major cases of high technical complexity and exposure severity for private and public entities insured by Travelers. Rodger has appeared in every Maryland Circuit Court and has tried dozens of bench and jury trials to verdict. I will take your questions throughout today's program. Just use the Q&A button at the bottom of your screen. We'll get to as many as we can as we progress. We'll save a little bit of time at the end for questions as well. Now to begin, I would like to turn to Judge McCally. Judge McCally, good afternoon.
Good afternoon.
So let's talk about the current status of operations of the court right now. What's the current status of hearings and trials in the wake of Montgomery County Circuit Court Administrative Judge Bonifant's March 4th, 2022 administrative order?
So where we are now is back to fully operational post-pandemic. And so everything is able to be conducted in person. Everything, jury trials have resumed, court trials in person have resumed, jury trials have always been in person here. And some proceedings we've learned, are beneficial to conduct them on Zoom, but that is up to each judge. So, for example, civil motions, we have learned through the pandemic that is actually beneficial to the bar to be able to be where they need to be and be in their office or work from home if they have to present those issues in their legal arguments. So that seems to work well. There's some other things that work well and some other things that not so great on Zoom, but we're learning as we go. And really at this point, if there is a request by council for whatever reason to have something proceed by Zoom, it is up to each judge and what their preferences are. Some judges here are full in person, some are like me, kind of a hybrid, and sort of depends on the circumstances.
So you mentioned things that are working well by Zoom and the civil motions calendar virtually. How does that work? And how do we know as practitioners if our matter is going to be heard virtually or if we need to show up to the court in person?
So I just finished a week of civil motions last week, and the way it works is ahead of time, it's indicated through my chambers that the hearings will be conducted virtually and the Zoom links are sent out. When, for example, if your hearing is set for on a Tuesday, then you'll have that link. You'll know the date like you would have always known it, but now through MDAC. And they are still called at the same time, and my law clerk will come out on the Zoom and let everyone in, and also try to find out what's truly preliminary and what is going to be a full hearing, so we can try to keep moving people on their way. So from that end, the triaging works the same in my courtroom. I think it works pretty much the same throughout our court, but you would get that notice ahead of time.
So it seems to me, in some sense, right, we're in our offices while we're waiting. We're not in the courtroom.
Right.
And people can then proceed efficiently on the civil motions calendar. Do I have that right?
Yes, and oftentimes when I know we have an order of whatever the preliminary matters are, if something's settled and they couldn't get the order to us or whatever, something's being moved, we take care of that. Then I sort of will tell counsel, I'm taking up this one, you're held harmless for 15 minutes or whatever. And whether they're here or virtually, I think it's beneficial to counsel to know that so they can either hop out in the hall or do something else while they're waiting for their case to get called.
So we've talked about things that work well by Zoom, maybe something that hasn't worked as well by Zoom. Let's talk about family court for a minute. I understand that you took a uncontested divorce docket a few months ago. How did that go?
Throughout the pandemic, once the court was able to open partially to all virtual proceedings, the matters that we were able to get going for trial or whatever, or a motion or something like that, were being able to be done virtually. It took a little bit to learn how to have counsel, for them to learn, us to learn, to get exhibits to us ahead of time so they could be uploaded into the computer. It was a bit of like pulling teeth because counsel obviously concerned, are we going to give this to the other side? And we were here drowning in binders, and if they'd had the time to look at any of that ahead of time, that would have been a whole different story. But that is an arduous path. So when lawyers were not following those instructions, they often found their case getting continued because my assistant, my law clerk, don't have 4 hours on the trial date to upload all of that material to the computer. So that was a learning process. When interpreters are involved, it is an additional process that has to be utilized in order to connect each person needing the interpreter to the interpretation function on Zoom, and also the interpreter. So a few months ago, and life is a learning experience, but I was given the family docket of uncontested divorces, all interpreter cases, which was great, except we had 8 different interpreters of 8 different languages. So instead of that being a sequence of what would be 15-minute hearings, it was, I don't know, I'll just say a nightmare, because each case had to stop, start over, explain to the participants how to activate the interpretation feature. And so the interpreters were stressed out because they had other places to be and anticipate a very brief hearing. The participants, many of whom were self-represented and speak different dialects of their first language, weren't understanding. So to say it was a nightmare was an understatement. So if your client needs the interpretation function, we will know that and it's very important that counsel make that request ahead of time. We have very few interpreters and they are literally running all over the building. So it's vital that we know that ahead so we can have that in place. And perhaps some instruction to your client that you're going to get instruction how to activate it. You just need to follow that. And then they will hear in their language and I will hear in mine. But when that was all happening, it was disastrous. So we got through it, but it was a challenge because of the need to go through those steps each time. And through nobody's fault except too many languages and too many interpreters to make that docket end when it was normally supposed to. So that would be one area that was a little difficult.
And I understand that some of those family cases are not only complicated, but also contentious.
Yeah.
Can you tell us a little bit about those kinds of hearings by Zoom?
Yeah, I mean, in any family case, that is always the potential. And there's a lot going on and obviously a lot of family dynamic. And I have watched attorneys trying to control their client as they would in a courtroom. Sometimes great success, other times not. And also depending whether their client's there with them or in a different location. And one of the issues becomes members of the community, I think, view Zoom like social media or something like that and not fully recognizing you're in court. So the inclination to just say whatever you would like or whenever you would like seems to be a prevalent issue for the court. We have the ability to meet people, and I've had to instruct my law clerk to do that many times because people do not act appropriately, because I think there is by virtue of it being virtual, there is a sense of either not as formal or a little bit less serious, if you will. And nobody here takes it that way at all. We've had people say very unpleasant things, that's always going to be the case, but also have other people there sitting with them to annoy the other party or whatever drama is trying to be created, which is completely unhelpful to counsel, to the court. Obviously, we're trying to get the meat of the issues. When people are trying to come into the Zoom on their phone, I've learned directly that's not so great because the connection's not as strong. And back to interpretation, that doesn't always work through a phone. So that delays everything. People think driving is fine. I don't allow that. So I will stop the whole thing if I see a car moving. It also makes you nauseous to look at. But if people start walking around their house, which creates this surfing effect that is really annoying. So there's a lot of things that it has just created this sense of complete informality, which has been, not that I'm worried about my sense of formality, but it detracts from the importance of what is going on to some of that. So
thank you for that honesty. So Daniel, let's talk about for a minute. I want to bring you in at this point. Talk a little about how to present a professional visage to the court, and particularly about backgrounds. Talk to us about what kind of backgrounds you use when you're on Zoom, and let's say it's a hearing or other court matter.
Sure. Thank you, Scott. So this is my home office background, and I like to use this for settings like this. I'm usually going to my office for something that's with a court, for a proceeding. like to use the real background. I prefer that. I've seen some kind of bad outcomes that come from using a virtual background. One of the examples that comes to mind was during a hearing, the witness, who was not my witness, was using a virtual background, and he had a chair kind of like this with a high back on it. And the virtual background couldn't decide whether that was part of his head or not. And so periodically his head would kind of shape out like a football. And it was distracting enough that I sort of chuckled a couple of times at it. If you're using a real background, I think we've all seen on Twitter, there are people who evaluate people's real backgrounds. I like mine here and at my office. Books, sort of office type things. Judge McCally has a great background there in her chambers. Something that is not distracting, but also, gives a setting to the person. In our office at Kator Parks, there our conference room that we sometimes use for depositions and for other things that are not virtual has a glass wall around half of the conference room, and people walk past behind that glass wall down a hallway periodically. Try to really avoid using that part of the office to make sure that there's nothing distracting going on behind.
Lighting. Any tips on lighting when you're in a court hearing or a court proceeding?
Sure. And I've found this to be particularly important to use the opportunity before a proceeding to talk with your witnesses about their lighting and to do a technology check. I had one client in particular who just was sitting in the wrong way where all of the light was behind him. So it washed him out. So it made him look like he was in a shadow. And I had him actually rearrange his entire living room so that he could be facing the camera and then with the light source from a window behind the camera. Having that light source behind the camera, or right now I have them kind of to the sides, I have two to the sides right now, is helpful in illuminating the face well. That was a damages hearing. So it's particularly important for the administrative judge in that case to be able to evaluate my client's credibility and see his emotion in his face when he was talking about his experiences in terms of his non-pecuniary damages. But the lighting can be very important. I know we talked about this, Scott, in terms of using ring lights. I know that is something that is becoming more common because it offers a good illumination of the face kind of all the way around the camera. But you can kind of make do with what you have. But yeah, make sure that bright light is not right behind the subject.
What camera angle? We've got, all of us have our cameras in front of us. Sometimes you see it on the side. Sometimes you see someone kind of looking down, maybe. What's your advice about camera angle? What kind of advice are you giving to your clients?
I think it's two parts. The first is you want to avoid sitting with your eye level really far above the camera lens. If you get that view of you kind of looking down at the camera, first, it's not very flattering for most people. And second, the idea of kind of looking down at the person who's watching you is never what we want to impart as counsel, I don't think. The second part is to try to make eye contact with the camera lens. This is something that I learned pretty early on in kind of the Zoom era here. It makes a big difference. And getting clients to really embrace that, especially when they're the ones testifying or you have witnesses for your side who are testifying, it just looks more credible. There's something important about eye contact, and it's impossible to do that if the person's looking at a screen to the side or trying to look at themselves on the monitor and it's above them or something like that. I like to make sure that I have my camera and then any notes or any witness script that I have kind of on a monitor behind and above the camera so that I can almost look like I'm looking straight into the camera, even as right now, actually I'm looking at my notes behind. It creates that illusion, hopefully a little bit more effectively. We've also set it up in our office where we will have the counsel who's examining a witness sitting across a conference table from the witness, and have essentially two cameras in between them, pointing in the opposite directions, so that the witness and the examining attorney can look pretty much at each other right over that camera lens on both sides. We found that to be effective too.
Daniel, thank you. Rodger, I'd like to bring you in at this point. From your perspective, what kind of virtual backgrounds do you use?
Well, I've decided to choose a virtual background today that I don't like, where it's blurred in the back. Because as Daniel mentioned, every time I move around, I'm going to disappear in part. So it has its poor effects, but it's probably the better choice than showing, in my case, my entire office, because that's just plain boring. So there's nothing exciting in my office background. So I just blur it out and show people that I can stay still, hopefully enough to get their attention, ask my questions, get their answers. I do have a nice courtroom background that I try to use on occasion to impart some sense of the seriousness of the proceedings that we're going through. When I'm not in court, but just taking a deposition, it still serves as a reminder to my clients and or to the other witnesses that this is a legal proceeding. So that's my choice of backgrounds.
Roger, when do you use your traveler's insurance company background?
I would never use the traveler's insurance logo in my background. I'm staff counsel for traveler's insurance, which means I represent individuals and companies that are insured by travelers, but references to insurance are not appropriate in the courtroom setting where the jury is not instructed as to who does or does not have insurance. So I don't use those virtual backgrounds that would say, have the traveler's red umbrella.
So let's talk about remote depositions for a moment. Rodger, give us a sense from, someone who's taken lots and lots of depositions. Which depositions are you taking in person and which are via Zoom in the wake of the pandemic?
Well, so it's been over 2 years now of taking depositions exclusively remotely. So we're using the Zoom platform, set up everybody's remote connections. And as Daniel suggested, you have those advanced meetings, hopefully with your clients, but I've seen people participate on their cell phone from their car. I had a truck driver who was working all day and, at the end of the day, he pulled over to the side of the road and wanted to do it. So we've had every situation, and it is somewhat more convenient and efficient if you can catch the various party deponents or witnesses at their home, at their office. It's not as much an interruption to their day. But now we are transitioning with the improvement in the pandemic. We are open for normal activity, but I still find the convenience, the speed of taking the depositions to be very favorable. I can now take a deposition from my office, and then rather than driving home and perhaps in my old age forgetting what the witness just said, I can take my notes or give my deposition summary, which from my perspective as a defense counsel is important because I have to communicate to others what I think I'm seeing as the potential exposure and value of the case.
So in addition to being more convenient to the witnesses, do you get a sense that witnesses who are in their homes and they're being deposed are more comfortable and therefore might open up to you a little bit more than they might otherwise if they were in your wood paneled office or somewhere else that they're unfamiliar with?
Well, that's a sense that's actually determined by my opposing counsel because in my case, plaintiff's counsel on the other side can say, well, no, I'm bringing my clients into my office. And in that setting, I prefer, since I'm only looking at the witness, I prefer the opposing counsel be in a separate room, in a separate monitor with his computer. But I don't press the point because I trust the members of the bar. They are not going to be communicating, passing notes under the tables with the right answers, I don't think. But it is somewhat a distraction if there is someone off camera and still in the room. So it's really up to the opposing counsel. I think sometimes if you see someone in their house, in their home setting, you get a better sense of who they are, what's important to them. perhaps how their injuries have really impacted them, somewhat of a day in the life video almost. And that gives me a sense of the seriousness of their claim.
Daniel, I want to turn to you now and just talk a little bit about depositions that you're taking by Zoom. Do you give opponents any instructions when you're on Zoom taking a deposition at the start of that virtual deposition?
I do. I think some of these are lessons that have been learned the hard way over the pandemic. I think the sort of most specific instruction that's relative to the Zoom is a lot of times a court reporter who cannot hear will interject themselves to let the proceeding know during a deposition that they missed something that somebody had said. And it's important during the instructions at the beginning of the deposition to let the witness know that when a court reporter does that or an attorney does that, to not rephrase what they've just said, but to say exactly what they had just said. There's this natural tendency when asked to say something again, to say it in a different way. And with the way a court record is meant to be created, the goal is to avoid that. So that's a good instruction to give. The other ones that we usually use as attorneys taking depositions are valuable and helpful. And I think especially the instruction to make sure to give enough time after a question is asked before answering a question so that there's not overlap in the transcript. That one is a little bit more pronounced on Zoom. When I'm instructing my witnesses before their depositions to give me a chance to object if I need to. So asking them to give me that nice real pause before they start answering is important. I like to talk a little bit about exhibits with witnesses beforehand. It's something that I coordinate in advance, usually with opposing counsel, to get documents to the witness if they're also remote, so that they have those documents, but ask them not to look at them in advance of the deposition, but to be sure that they can access those files so that we're not fumbling around with computer files and emails and things like that during the deposition. And I've actually found that most witnesses are compliant with that. They'll actually let me know on the record that they have the documents, but they haven't looked at them in advance. So that's always helpful to have on the record too.
And do you send those by mail? Do you send them by email? How do you get them there?
I've been sending them by email. I can email opposing counsel. I usually try to do it, the afternoon before or sometimes the morning of it if it's an afternoon deposition. So there's not too much advance time, but sending them as an email package and then just giving that instruction to ask the witness to verify that they can access the file without actually reviewing the documents. And that seems to have worked pretty well thus far. Let's
talk about speaking objections just for a minute, because sometimes speaking objections becomes a problem. Have you found that this is easier, harder to deal with via Zoom? Where do you come out?
I have found in my experience that it's a little bit easier to manage. I think that part of that is that other attorneys are showing respect for the Zoom circumstance, knowing that a lot of times the way the audio system works on Zoom is it will only kind of pick up one speaker at a time, and that can get really garbled on the record. Whereas in a real setting, attorneys who are even talking over one another, they'll hope at least part of that gets picked up by the court reporter. But I have also definitely, use the tried and true method of asking to go off the record and having a sidebar conversation with counsel to try to quell those speaking objections. And I've found, I don't know if it's something about being remote or not being in the same room, there's sort of a less confrontational or less adversarial tone to a lot of these depositions. And so that does help with those speaking objections.
And the fact that the counsel making the speaking objection, like I am right now, that ribbon goes around their view, and that's on the tape as well. Right,
absolutely. I think that's something to be very cognizant of when you're doing this. I like to think of it as not only being an attorney, but being essentially a movie director of some kind. You've got to kind of always be aware of those changes and how the technology is presenting what to different people at different times. And that's particularly useful when you're doing hearings. And I think we'll maybe talk about that later.
Special admonitions you give to witnesses that you are deposing via Zoom. What are they?
I've talked about this with a couple of witnesses where it's come up. As Rodger was saying, a lot of people will give testimony from their homes now. the admonition that there shouldn't be anybody else who can kind of hear the proceedings or sort of be part of the proceedings who shouldn't be there. That's important. It usually only comes up when I can detect that there's somebody else. I remember being on a deposition at one point and hearing somebody's husband in the background, and it was clear that I could hear them, and so they could probably hear what was going on during the proceeding. So we went off the record and dealt with that then. But in terms of other admonitions, it's mostly the standard ones that we have all been using kind of from earlier practice.
Talk to us about recording the Zoom deposition, Rodger. When you are taking a deposition by Zoom, some lawyers simply use the record feature in Zoom. Some say, no, I want to have the videographer record that deposition. Which way do you lean?
Well, I prefer to have a videographer if I plan to use it as a trial testimony, or to perhaps go back and have a good format available for use at trial. I do believe the Zoom has the option of recording, but the videographer and the Maryland rules require a certain notice in advance as to the fact that the video deposition may be used at trial, and that the videographer traditionally reads the opening comments and the closing comments, keeps track of where the objections are made throughout the testimony, and that all facilitates the later presentation to the court as to, hey, Your Honor, we need a ruling on whether or not this comes into evidence. So I prefer a professional videographer when it's more than simply a discovery deposition. The majority of my depositions, however, will simply be set up through Zoom, which means I'll have the court reporter available, not relying upon the electronic audio recording, but having the stenographic recording made at the very same time.
Rodger, we got a question from Henry Nash. He says he's very concerned that the drawbacks of using Zoom outweigh the benefits. Many benefits to person contact, he says, are lost with Zoom. I am an ENT lawyer with an emphasis on elder law and disability law. I am particularly concerned about using Zoom when dealing with seniors and disabled people. Rodger, when you've got someone who is senior or disabled, any special considerations there when you're thinking about taking that deposition by Zoom?
I assume the panelist asked me that question because I'm the oldest, if not the oldest person in the state of Maryland. And you can see I do have headphones on, which to my advantage, sometimes is even the audio comes through better. And so with technology, you can also work around some of those disabilities. If the elderly person can't get out of the house, I'm dealing with a claimant that is severely disabled. It's actually a convenience for them to be able to communicate through home, but they need to have the technical equipment necessary, including headphones or correct speaker volume, so that they can hear that. I do agree with the questioner in terms of you get to know people better in person. As much as we've become accustomed to watching things on television, it's still the preferable atmosphere to say hello and be able to shake hands if the pandemic allows, and to watch and see and observe. And that's something that you're always doing, even on the Zoom panel. You're looking to see who is this person we're dealing with.
Daniel, let's talk about defending a deposition. Are you in the same room as your client when you're defending your client's deposition, or in two separate rooms?
Yeah, I was interested to hear Rodger's preference that I might be in a separate room for my client, but I've been in the same room with my clients for depositions, for my clients' depositions. We have the camera just on the client, and I'm, playing by the rules by just sitting next to them and not coaching or anything like that. And it seems to have worked just fine.
Rodger, you mentioned the kind of prep sessions that you do for witnesses, maybe before a deposition. Let's say it's your client as an example. apart from what you do normally, are there any additional things that you are reviewing with your witnesses in anticipation of a virtual deposition now that so many of these are being taken by Zoom?
Yes, there are. The standard instructions that I give to a client remain the same. First, make sure you've heard and understood the question. That is particularly important in the Zoom world because, as we've mentioned, sometimes there are less than favorable connections. And so you have to make sure that you've heard the question and understood the question in the Zoom platform before you can give the answer. And then the second standard instruction is to, once you've heard and understood the question, give the honest answer to that particular question. This is a court of law, and they do have to tell the truth. And I tell them, you can't really be concerned whether you think it's good, bad, or indifferent in terms of how you answer it. The primary concern is to answer it special. I mean, honestly. But the special instructions that I would give with respect to Zoom is to talk to the witness ahead of time on the same platform that we're going to be using, making sure they have the computer equipment, have the Zoom connection, have a quiet place where they're not going to be disturbed or distracted by people walking back and forth.
So Daniel, now that so many depositions are taken by Zoom, which are the depositions that you're taking by Zoom? Which of the depositions are you taking in person?
For the most part, still, so our practice is predominantly in the federal sector. A lot of agencies are still expressing a preference for remote depositions, and we're willing to accommodate that in most cases. It is also just more cost effective for my clients. Rather than having to fly me around the country to do in-person depositions, I'm able to do it by Zoom and pass a lot of cost savings on to the client. I would still prefer to do most depositions in person, I think, if it were an option. But right now, because of the convenience, it's kind of the default setting to be able to, like I said, pass that cost savings. And then also, as Rodger mentioned, time savings on, instead of having to even travel across town, it's something I can finish up the deposition and then move right on to my next task. But as I said, many federal agencies are still requiring video. It's a little bit diverse, though. I had one agency, I think it was FAA, they were adamant that we do in person. And so I did do that flight across the country for that one.
Daniel, we got a question from Richard Schimmel, and he really asks about the technical mechanics, and particularly the issue of reverb when two computers are too close to one another in the same room. How do you deal with that?
Sure. It's just a matter of making sure that you're only using one microphone at a time. It definitely happens. And if I'm in a situation like I was describing where there are two people across a conference room table where they're trying to look at each other while also looking into their video camera lenses, we make sure that there is one microphone that is on and then the other microphone is off, and it's that microphone that's kind of between the two, and it's the one with the better gain on it. But that can definitely happen, and obviously that's just kind of not sustainable to have that really kind of obnoxious racket going on. It also comes into why I like to be in the same room with my witness when we're doing deposition or proceedings or whatever it is. Even with the walls and everything like that, you can sometimes get that background feedback. You can get that background noise coming in. It also, for a lot of reasons that I think are somewhat obvious, but you want to be able to be quick and things like that. It's just, you feel better being right there with your client or with your witness to be able to do that. So there are a lot of advantages to being in person with the other person. Again, the big tip here is try it out in advance. If you're going to experience that reverb, you want it to happen during a test rather than with the administrative judge waiting for you to figure it out. I can't emphasize that enough.
Daniel, thank you. Judge McCally, I'd like to bring you back in now and just talk a little bit about Maryland Rules 2-802 and 2-803, which authorize Maryland Circuit Courts to conduct remote proceedings. How do you decide between a Zoom hearing and a telephone virtual hearing?
You mean with audio only?
Yes.
Well, let me start by saying when testimony is involved, I'm going to always lean on the side of in person, when possible. Everything that Daniel and Rodger have just been talking about of their preferences and why, and importance to remember this is formal proceedings are really important. And when someone's on Zoom, the issue that I always have is someone sitting there with them, coaching that person, especially when they're not with their lawyer. And it becomes particularly complicated in a criminal case because in any case, but particularly that, because it can affect the right to confront the witnesses. So what goes into my consideration is what type of proceeding is it? Is it contested? Are there reasons that more than usual or more pronounced than usual that one might have to have their answers enhanced or changed or modulated somehow? And that is a big concern, because if somebody's across the country and someone's behind them holding up signs what to say, that not that counsel would ever participate in that, but I've had all kinds of things happen on Zoom that would shock all of you to know those details. Maybe not, but it shocked me. And so that is a very big concern, I think, for all of us. And so when it's anything like that, I am going to require that to be in person. If it's a default judgment, damages only, stay wherever you are and we'll hook up the Zoom. It is, those kind of things. There's a sheet of damages. There's not a whole lot of mystery what's going on there. So it really depends on what the proceeding means. One thing I learned through, and Daniel was speaking to this, when two are in the room together, when you use the client and the two computers are competing microphones, first of all, it's almost deafening, and then it makes the Zoom freeze and all of that. So it gets a little logistically, at first it was very logistically complicated, but I think the bar has their up learning of what to do with Zoom has been exemplary. And so that seems to be pretty much understood at this point. I think also when your client is with you, they tend to behave a little bit more like they're in court, if that makes any sense, and not just kind of go freewheeling or want to just interject things. I've had many people just think they're going to help their lawyer and start chatting, which is so unhelpful. Just many things like that. But always when the issue of credibility, veracity, cross-examination, is this fair to the proceeding? Is everybody having due process, or we don't know what's actually going on? I will tell you, I didn't know it at the time. I knew something was wrong because one litigant in a divorce case kept turning off his camera, and I'd say, well, I don't know what you're doing. You can't do that. I learned later he was smoking a bomb. Thought that was a good idea. So you can imagine how that custody ruling went. But I didn't know he was doing that at the time. I had much more evidence to make that decision without that, but I think I would have called CPS if I'd known that. So this is what I'm talking about. The things that people think they're going to just do because they're going to do them impact greatly the court's decision-making process, what has to happen. It can negatively affect the presentation of people that are walking by and music starts or the dogs, or, we were all living in some pretty weird times, so had to do what we had to do. But if it's testimony to a factual decision that has to be made, I think that would be the way to suffice it. I'm going to lean on the side of moving it in person.
So I understand that in addition to witnesses who maybe have gotten a little too comfortable when appearing remotely, there have been some lawyers who have also maybe gotten a little bit too uncomfortable. Can you tell us about what you've seen?
Yeah, I mean, I think we're all learning how to get back, in the main lane of life here now. I've had lawyers show up in sweatpants, pajamas, tops, all kinds of things. And first thing everybody needs to remember, while the court might have been closed to filings and trials all got moved and all of that, we were all here. And we were here every day, just like going to work. It was pretty odd to have 40 people in the building, but we were here. So when I see a lawyer dressed like they're going to play golf or tennis or just got out of the grocery store, we all have to do those things, but it troubles me because it reflects on our profession, and that's not who we are. And so nobody wants to wear all these ties and suitcases, and I get that, but we haven't relaxed to that point, and it diminishes the impact of courtrooms, I think. So yeah, when I see that, and I see that on a big Zoom screen where sometimes I've had 20 little camera pictures like Hollywood Squares up here, and I see lawyers dressed, then the clients or the litigants are thinking, oh, I can do that too. And I've had people do a host of things on the camera that would just shock you, where they don't ask for a recess, they just take the Zoom equipment into the bathroom with them. And then I'm my attorney, oh, we're not doing that. So truly, not lawyers, haven't had a lawyer do that. But there's just this sense of anything goes sometimes. And when lawyers don't make sure there's a distinction with their clients that's well educated to the client, it has a diminishing effect on the process, I think.
So you have a list of best practices, advice for practitioners preparing themselves for virtual hearings. Can you go just through a few of those with us?
Sure. I think Daniel talked about the problems when people are on separate computers in the same room. That seems to be pretty globally understood at this point. It still happens, but it's not, I think everyone sort of knows what to do now. So I won't dwell on that. But phone connections, like I said earlier, they are often very problematic, and they drop off and freeze up, and it seems like no big deal, but it stops the whole process, and then everyone has to remember where were we, and it takes 5 minutes to get everyone back in. And if you have that interpretation feature, add 20 to that. And so it is important for lawyers to counsel with their clients if it's a Zoom hearing. If they're not going to be with you, where are you going to be? What is the connection? It needs to be a solid connection that's not going to, and not that people don't drop off on a computer, but that's going to be less likely for that to happen, because it takes away from their ability to have their case fully presented and not with a bunch of distractions. No driving. Last week I had a attorney, I said, I don't know what you're doing, but when you park, let me know, I'll recall your case, because I'm not watching you driving down a highway while we're having a motion to suppress. So figure that out. One thing is important, if you make sure your display says your name and not, Johnny's computer or Poppy's computer or whatever, because especially when the civil motions docket or maybe the guardianship docket, that comes on and it'll say, go commanders or whatever it said, and I don't know who that is. So then it makes it extremely difficult for the law clerk to know which group of people are with which case. And again, all of that just detracts from our ability to devote our attention to legal issues. So that sounds small, but it's big at our end, especially when you start talking, because then I know, okay, plaintiff's counsel talking, defense counsel talking, then I know who's actually speaking. One other thing that's important, when you get the link from the court, if you make sure Chambers has your phone numbers in case there is a drop off or if something's frozen or you drop off. I know lawyers naturally are going to extremely worry. We often realize, whoa, we've lost somebody. And then when we get the call, they're trying to get back in. That's very helpful and reassuring to you as well. So just make sure we have that. It goes a long way. as we're doing now, stay on mute till you're asked to unmute. If you're not admitted into the Zoom session on time, you can certainly let chambers know you're trying to get in, but 10 calls are not really helpful. We know that we might be having a problem getting it connected, or we're finishing up some other matter, and then we have to pull the Zoom equipment over to the middle of the courtroom. So anything can be happening, but we appreciate the notice, but just not repetitive calls about it. I talked about the interpretation feature. Exhibits, I think many lawyers are now really excellent at putting them up on the screen yourselves, so that helped everybody. But if not, and you need to have them uploaded at our end, we have to have those ahead of time, or your case is likely to get continued because we can attribute that time to that. And I think the efforts that counsel are making to make sure their clients are fully ready to proceed by June have really enhanced where we are now with Zoom. We were probably a minute or two short of two cans and a string at the beginning, and I think we've all come a very long way. So I think that it has become a tool. It can become our enemy. So when we find the balance in which cases that works the best, then I think it benefits the practice and the court and the litigants as well.
Judge McCally, thank you. Daniel, turning to you, talk to us about how you use video hearings to your advantage.
Sure. One of the things that Judge McCally just mentioned is something that has come up in terms of how I'm trying to use the video to my advantage. And I think I mentioned it earlier, I like to think of it as almost putting on a video production for, in my case, it's usually administrative judges, but for the judge. One of the things that Judge McCally mentioned is that sharing documents, people have become more proficient with that. I had a Merit Systems Protection Board administrative judge who let us know that it was important for us to show the documents and make sure everybody could see them, and so everybody knew what we were talking about, but to also take them down as promptly as possible. And that was because he was watching on the video screen, and so if he was looking at a tiny view of the witness, it makes it harder for that judge to make those credibility determinations and evaluate the live testimony in a way that's important for the judge. So taking into account thoughts like that, we like to use the document sharing and video, and I think a lot of practitioners got used to this in the live court setting, to really zoom in on what we're talking about. And I found, especially during that hearing I was just mentioning, really making sure that my script in advance was zeroed in on exactly what parts of documents I would be using. And then showing the documents in a way where we can get the witness to identify them by looking at the top of a document, say an email, looking at the to, from, date, ray lines, identifying that document, getting it entered appropriately, and then going straight down to the part of the document that's relevant to the testimony, and then taking that document down so that it's just the video feed from the witnesses as quickly as possible. There are other things that, and Judge McCally mentioned a witness taking bong hits during a trial or a proceeding. We like to use that time off screen appropriately so that we can go off screen and have a conference, amongst ourselves, amongst counsel and witnesses, but to be appropriate with that and sparing with that, including to avoid creating a misapprehension about what's going on off camera. But we've found that sort of that quick way to go off camera to be really more efficient than can usually be done in in-person hearings, so that we can use that to our advantage too, to kind of speed up the proceedings and have those conferences a little bit more quickly.
Daniel, thank you. Rodger, you are participating in hearings in circuit courts all over the state. What have you found now that we're in 2022? Are most of them in person, most virtual, a little of each? What's going on?
It is a little of each still, but the tendency seems to be going back to normal personal appearances at the courthouse. The Circuit Court for Montgomery County, my understanding is that they have the discretion to still conduct hearings virtually. And I think that works very well, where it's just argument of counsel. And perhaps, as Daniel suggests, counsel can share its screen and put up a particular document, and that goes right in front of everybody's face. It's an easy way to hand or to highlight the material for the judge's advantage. But ultimately, if there's no concern with the pandemic, I think the in-court appearance, and I say this as an old person, is still going to be better.
So in terms of kind of which that you prefer, right? You've got on one hand, you have the convenience, being able to be at your office, not have to travel. On the other hand, you have the personal connection. What do you prefer?
Well, for example, I've had 2 arguments this year at the Court of Special Appeals, and so I think it's actually helpful to the presentation to be in your home or office setting, and as Dan has explained, to be able to have the setup where you can refer to or turn to your own notes or to look at particular documents, perhaps on multiple screens. So that's helpful in the appellate argument setting. It's also helpful to see the 3 judges in front of you as you're arguing. You sort of have a close-up view. But again, I guess over 40 years of going to court versus 2.5 years of virtual practice, I still always enjoy my travels, be it to Annapolis, to the appellate court, or out to Western Maryland. I was out in Cumberland not too long ago, and some of the attorneys I was talking to out there, including the county attorney, said, yeah, we've had 1 or 2 virtual depositions over the past 2.5 years. So I think it does depend upon the jurisdiction and their preferences.
How do you handle exhibits remotely, Rodger, when you've got a virtual hearing? Let's say you want to point to an exhibit, for example. How do you handle that?
Well, in a hearing situation, the motion has already been filed with all the exhibits. So it's just a matter of sharing that exhibit on your screen. The court already has it in its possession, but you're pulling it out and highlighting it at that time. The same with the appellate practice. Everything that the court is willing to refer to is already in front of the court in terms of the written record. In the discovery practice, though, normally all the documents have been exchanged. Written discovery typically, not exclusively, but typically is completed before the discovery depositions. And so I don't necessarily find it necessary to send my deposition exhibits to opposing counsel. But if there's going to be a vast number of those, he probably has most of them already through discovery. So it doesn't hurt to highlight them in advance. And if it's particularly complicated, I can ask for a technician to join us through the court reporting service. And that technician has all the exhibits uploaded in advance, and I can sort of transfer that task to the technician and just say, would you bring up the pre-marked exhibit?
Daniel, let's talk about impeaching witnesses with documents remotely. How have you found that?
This is one area I've actually found almost more effective. I still do have preference for in-person. I think Rodger makes a lot of important points about why the value of in-person proceedings, shouldn't go away. But when it comes to impeaching, there's something almost more confrontational about having that document projected on the screen. To be able to have the control that you have manipulating a document using a computer system versus, kind of the awkwardness of fumbling with something with paper and walking back and forth through the well or something like that. Having, obviously your impeachment's laid out in advance is important, but to have that laid out in advance and have that sort of a click away it almost creates kind of a suspense for the witness. I found this to be particularly effective. I was examining an 1811 law enforcement officer, a federal law enforcement officer. So somebody who's done plenty of investigations themselves, have testified a number of times. But I found that I was able to kind of keep him off balance by working through questioning and then kind of leading him into an impeachment in a way that was, I was able to conceal it almost from him, including because, I was able to sort of take a pause and then put a document right up on the screen to effectuate that impeachment and having it just sort of pop up there. I think was very effective both for the witness in terms of them sort of realizing what has become of their testimony, but also for the judge to see that in sequence, so to see that live testimony and then immediately see the document as I want them to see it. And that again goes back to what I was saying earlier about making sure you know where you're going in your document before you put it up on the screen. So you can zoom it in right on that part of the deposition transcript or the document, that's already an exhibit. You have it pre-selected, and so when you go to share it, it's exactly where you want it to be. So it's immediately the thing that the judge and the witness see.
How about using a witness's prior testimony to maybe impeach them with an inconsistent statement? How have you found using Zoom for that purpose?
Yeah, it can be a little harder to do, I think. And this is where sort of the live versus virtual does come into play a little bit more because you're not in the same room. That kind of interpersonal interaction that happens is absent. But like I said, I think a lot of it is having that down pat beforehand and making sure that when you're using that prior inconsistent statement, that you're just showing that. And so you've done that sort of in a pre-selected way.
Now, we can't see it, but I understand you have a 3-screen setup.
I do.
Why
I do.
do you have a 3-screen setup?
I like this setup. So it's actually a laptop with my video camera at the top of the laptop on the edge of that. And then I like to use 3 screens. I like to be able to have my notes, especially for a hearing or a deposition, right above on the second screen. So that's directly behind the camera, as I mentioned earlier. And then for these platforms, it actually matters the relative size that you expand a document to when you share it. So I like to be able to use that third monitor for my document sharing so that I can blow up those documents, be it an exhibit or, as we were talking about a moment ago, a deposition transcript page, as large as it can get on one of those monitors, so that when it shares, it's big, and then that zoom in is more precise. So yeah, I maybe am a little greedy when I use 3, but I find it I am using all 3 when I'm really humming along.
We got a question from Art Smith here. He's got a number of questions. I want to deal with a couple of them here. He asks the pros and cons of using Microsoft Teams versus Zoom. Daniel, what's your view?
To be honest, I am not finding a huge difference to the extent where I will express a preference myself. A lot of times, again, our practices against federal agencies and before federal tribunals, including the Merit Systems Protection Board or the Equal Employment Opportunity Commission administrative judges. A lot of times the agency themselves will have either an internal policy where they cannot use one platform or the other. And so we're willing always to accommodate that. I do find that the smoothness of Zoom is a little bit better in most of my experience. I've had more issues where people stop being able to see a shared document or are unable to see their own video. I feel like that happens a little bit more on Microsoft Teams. That may just be anecdotal. I don't know that that's supported by any data. But I think if I probably had a preference, it would be for Zoom, just for that reason alone.
Thank you. Judge McCally, I want to talk a little about remote testimony in otherwise in-court proceedings. So 2-803 permits the court to authorize a witness to testify remotely in an in-court proceeding. I just want to discuss the kinds of witnesses that you would permit to testify remotely. Let's say it's a jury trial, and counsel wants one or more witnesses to appear remotely. How about a business records person that is authenticating business records? How are you going to feel if you get that kind of motion?
Yeah, I mean, those are the kind of things where we've advanced to where this is actually helpful. I think that's perfect. Yesterday I had a proceeding in a criminal case, and someone at the Department of Juvenile Services is in Harford County or wherever. And so rather than have that person driving, 5 hours total, we could just get them on Zoom and they don't have a dog in the fight. They just have the information they have. So to me, that's a really great way to keep us moving. And I know you all are calendars are jammed beyond belief. Ours are exploding. And so I think that's all really good. To me, it's the fact that in the case where I have a problem or the litigants themselves, for the reasons I kind of already alluded to. But I think all of that is very helpful.
Well, treating physicians, the ones that are very busy doctors, let's say, and they want to ask them about the records. How are you going to feel about a motion on the treating physician?
Well, usually in civil cases, we have all doctors. It's rare that the doctor actually shows up unless it's pretty hotly contested medical malpractice suit. So we have the plaintiff's doctor, doctors by video deposition. We have the defense doctors, experts by video deposition. So all of that is not much different than Zoom. So I'm used to that. An expert, in my mind, are they really going to be caught off guard with the Harry Mason question? I don't really think that's happening. So it depends, and if somebody objects, then I'm going to listen to why. And I'm not wholesale just saying, sure, come that way, like virtually. But if it's mechanical or in order to keep the evidence moving, I have no problem with that. Doctors, I understand they have to be where they have to be, and maybe it causes less of them yelling at the lawyers about, you said 1 and it's 4, and so. I will also say sometimes lawyers look bug-eyed when they say, so my doctor's only available for 20 minutes tomorrow, and this is it. So what are we going to, well, okay, I don't know what to tell you, but the summons was served. So the doctor will, have to adjust. So if this helps that to some extent, I think that's great.
And what I'm hearing from you too, you experts, to kind of cut down the costs, you're open to a motion.
I am.
Those experts.
Yeah, I'm not speaking for my colleagues, I'm speaking for me, and I'm open to the motion subject to the opposition. And if that's a strenuous one, then I'm going to balance, what's going on. But I think across the board for everybody, I think Rodger was just talking about the cost, and Daniel, that, this is not what an airfare might used to have been $200 is $700 now or whatever. We're in a different time. And so if I can accommodate the moving forward of a case, and that's one more case that we can get people the answers to their important questions, then I'm happy to help that way, as long as I don't believe that due process is being tested.
How about a witness that has tested positive for COVID? They're still in their quarantine period, for instance, and the one party says, hey, look, Judge, there's a witness that I can't get into the courthouse because they're still quarantined.
Yeah, I would rather they not come anywhere near me. So, as fun as that is. So if they're up to it and the other side doesn't oppose that, my sense would tell me that there have been a number of cases where a litigant sometimes will use COVID as a reason they can't come to court, maybe more self-represented, divorce cases, child support, stuff like that. But it happens, but we don't know. So we have to give the benefit of the doubt. If they're up to it and the other side doesn't object, I don't, again, if I can get the case resolved, I'm happy to do that without doing harm to our legal system.
Thank you. Rodger, I want to bring you in just for a minute. Your thoughts about witnesses testifying remotely. Let's say it's a jury trial, but you've got some witnesses who are in different states. Maybe it's a doctor and the like. What's your view on how often are you asking that witness be permitted to testify remotely, and how are you responding if the other side wants to do the same?
I agree with Judge McCally's comments on that topic, Scott. I always would prefer to have my witnesses live in the courtroom so that they can be personally observed by the jurors, by the judge. And so I can emphasize this is an important witness, and what he has to say, I want you to listen to, because he's here in person to tell you that. But as a practical matter, and as the court has indicated, the doctors are too busy and too expensive to put them on call for an entire day or maybe 2 days, because I can't guarantee when they're going to be called on the witness list or what time we're going to reach them. So the normal practice for the medical testimony, that will usually, most always, be on videotape, which I have the doc in the box and I can just pull them out when we have a break in the proceedings, when there's the opportunity, and I don't have to worry, is he on his way? I've had other experts that are not as expensive or perhaps even more critical, such as accident reconstruction experts or a meteorological expert where the weather is an issue in the case. And just having them in person is, again, preferable. But I agree with, there are a number of occasions when the witness is no longer in the area. And the only way I'm going to get them into the courtroom is by a video remote link. And in that situation, even if it's not just a technical records person, if I can't get that person to the courthouse any other way, I'm going to need to ask the court's permission if we can do that video link.
Judge McCally, I want to turn to masks in the courtroom. When can a witness wear a mask in the courtroom?
Well, if somebody wants to wear a mask, we certainly are not going to inhibit that, but nobody's required to wear a mask, as it was for stretches of time. So usually what I do, if somebody's on the witness stand and they're still wearing their mask, it does become difficult to hear people and to fully hear what they're saying, especially if there's an accent. It has a distinct, the mask for anybody has a distinct muffling effect. So it does become really hard for a jury to hear, for me to hear. There's lots of other little sounds going on in the courtroom. So what I typically do, because I don't want to offend anyone either if they feel strongly about wearing the mask, is to tell them, if you would like to take the mask off while you're here, you're welcome to, or while you're on the witness stand, if you would like to, it's certainly fine with the court. And sometimes people aren't sure. So I'd say probably half the time people then take it off. Sometimes there will be an inquiry, again, maybe in a criminal case where there's an identification issue of the person or the defendant or the witness, or and so counsel may ask for that. So then I would ask the person to please take their mask off or down for momentarily for whatever the question is. And then once that's done, and I will tell them you can take it off and leave it off if you would like, or once this line of questioning is complete, you're welcome to put it back on. And I think it actually helps the process move along better, because we would never want to find out that a jury didn't know what to do with the testimony because they couldn't hear it. And, in our courtroom, in my courtroom, I'm on the old side of the circuit court building. Our acoustics just run themselves. And so there's a little microphone that goes from the witness stand to the jury box that I don't think think it's worked in 15 years. And so I always tell people, just pretend whoever needs to hear you is out in the hallway, or they're your kids and they're not listening, because nobody's going to hear anybody. And I can be sitting right next to them, and my husband would tell you I can hear people 5 tables away in a restaurant, but not in the courtroom. So that becomes a big issue, and we don't want that to inhibit anybody having an answer to their legal issues. So that's how I handle it, and I feel like that's how most of my colleagues handle it as well. And some people are very happy to take it off. Others have whatever their personal reasons are, so they can accommodate both. And I haven't had anyone, when I've told them, I need you to pull that down for a moment, I haven't had anyone object. And the witness stand in my courtroom, and I think in the South Tower too, the way they're set up certainly accommodates any social distancing issues. When we were trying to start trials again before, was it Omicron revved up, we had witnesses up there with shields and masks and everything except saran wrap around them and everyone else. So I couldn't hear anything anyone was saying. So I was glad there was a jury, but so that made it very difficult. So I think this is a great way to accommodate people's needs and their concerns and keep the case moving.
Judge McCally, thank you. Rodger, I would like to turn to you now and talk about an intricacy of the practice now in Prince George's County, which is the selection of a jury via Zoom. You are one of those lawyers who've had that experience of choosing a jury via Zoom. Tell us a little bit about the experience. It must have been a little bit anxiety inducing to know that
It was certainly
you're going to be
different.
selecting a jury by Zoom.
It certainly was different because you had everybody that was participating on multiple screens. So it was Hollywood Squares gone wild with all the people. But again, there were some things that you don't get in the typical in-person jury selection, because you could see where they lived and their backgrounds and their attitude came across more clearly than just asking questions. But it was a very time-consuming process. It was largely directed strictly by the court, without opportunity for the attorneys to ask for a particular juror to be brought into a private setting room, which you could do. The technology works. You can move people in and out of conference, but that was not done. It was just one large, long process. We did get through that jury selection after an entire day. And if I'm recalling correctly, the next day we were in person in Prince George's County. It was a wrongful death case, and we were all participating with masks across our face. And if the judge has hard time hearing the witnesses with the mask, you have to be concerned that the jurors, to the extent they wanted to pay attention to you anyway, were having a hard time with your mask on. But it was better than postponing the matter until everything passed in the pandemic. And 2 months later, I think I was down in Anne Arundel County, and instead of picking the jury remotely, we came in the first day and we went to the juror room, the assembly room, and everybody was spread out. And that was the attempt at social distancing. When we got into the court itself, we no longer were required to wear masks. So there's a tendency to go back to normal. And with the jury selection, I again vote for in-person, despite the fact that we need to Zoom into the future. I'm willing to do everything in person when it comes to selecting a jury.
During jury selection, though, as I understand it, you got the opportunity to address your questions to the entire venire rather than just to one individual person. How was that?
Yes, and again, typically you submit standard voir dire questions to the court, and some of them overlap with opposing counsel's questions, and the court will ask those questions. But you normally get to have a follow-up to the jurors that respond. And we had multiple respondents to questions, and if you needed clarification, the court just gave you an opportunity to ask that. They didn't separate any of the panelists, so everybody heard the question. It's a little frightening because you don't know what that potential juror is going to say, and he may say something about, oh yeah, this is really bad, or that type of case really requires this type of outcome. So again, it's a greater risk than being able to call the juror up to the bench and ask the questions more in private.
I'm going to turn to final thoughts in just a minute, but Rodger, I want to ask you just a little bit about how Travelers works. How does Travelers hire outside counsel? How does that relationship work? You inside, Travelers outside counsel. How does all that process work at Travelers?
So I started practice in the government setting in the Attorney General's office. One of my supervisors said you need to get out and get some more trial experience. So I found a small private practice firm at the time that did exclusively insurance defense work. And at that time, for example, the panel counsel for several insurance companies, if the case looked like it wasn't going to get settled, they'd send it to outside private counsel, panel counsel, which I was at that time. But the tendency was to go towards staff counsel, in-house counsel. And now at Travelers, all the cases will first come across my supervisor's desk, and they will decide whether or not it's going to be handled in-house by someone like myself or sent out to panel counsel. And panel counsel is selected when there is a conflict where we cannot represent that particular person due to a conflict. Panel counsel may be selected if we don't have the manpower at the moment, or if there is a particular complexity. I like to know everything. I'd like to know everything, but then I look like I don't know anything. So there are certain cases that are too complex for me and for others, and they will go outside as well.
Rodger, thank you. We are ready for final thoughts. Daniel, start us off.
I just want to start by saying thank you, Scott, for being a really wonderful moderator today. It's been a great panel. I think the big takeaway from this is that Zoom proceedings and Zoom hearings and depositions are here to stay, at least for some respects, and that we can all kind of learn and adapt them into our practice in a way that is purposeful. Plan in advance for them, be cognizant of the details that will help give a better presentation. Little things, there are now peripherals for your computer. There are a big button that tells you whether you're on mute or not with a big green or red light. If you're having trouble with making sure you're on mute or not, that might be something that can help you. But paying attention to these finer details will help make the presentation better. So thank you all.
Daniel, thank you. Rodger?
My thanks as well for inviting me to participate. I really enjoyed being with the panel. I think whether we do it remotely or in person, the important thing to emphasize is we are engaged in a legal process that dramatically sometimes affects a person's life. And so I find the opportunity to conduct more depositions and to see without a lot of time driving back and forth, to see what that person has to tell me gives me an opportunity to evaluate the case accurately and to have a sense of what the true exposure and value is. Ultimately, my goal as a defense attorney is to prevent any judgment against my client. But if I can't do that, and I can't, do that all the time. The next approach would be to keep the judgment as low as possible. But what I like about the practice of law is that it does reach a reasonable and amicable resolution. And I think the Zoom opportunities add to that, where we reach a good outcome in the legal system.
Rodger, thank you. Judge McCally, you have our last word. Final thoughts.
Well, first of all, thank you very much for this opportunity. I believe I speak for the whole court when I say that we appreciate counsel's efforts in keeping us all moving forward and your willingness to work with us while we learn to Zoom things and we had no choice. And I can't imagine what the backlog would look like without it. So that has been a blessing. It's also been really helpful to me today to listen to the issues that counsel deal with from your end, and now where we have advanced to in the Zoom world of what issues you all deal with in getting ready to come to court. Some more than others, but in your preparation efforts. But it is very helpful for me to hear that and to learn what works for you all, and also to be reinforced that all the members of the bar also share the same concerns to make sure that we are getting people's cases litigated fairly within the bounds of the law and as expeditiously as we can. So I really appreciate the invitation to be here. I appreciate it very much. Thank you.
Thank you. So Stephanie and I want to thank Judge Cheryl McCally, Daniel Clark, and Rodger Robertson. For more about the Bar Association of Montgomery County, you can find us at www.barmont.org. For future programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.MWELA.org. Thanks for joining us. We'll see you next time.